Please welcome the Honorable Judge, the Honorable Justice from the Court of Appeal of Spain, Mr. Justice Pascual Ortuño. Good morning, dear ladies and gentlemen. It's a great pleasure for me to be here. This requires profound reform, high conflict in post-divorce parental relationships. Even there are certain realities in Europe which are very different, depending on the different states. There's been a very important transition in family law in Europe, and particularly in family conflicts. Conflicts traditionally belong to the private law, the sphere of private law, and were managed by the basic social structures, mainly by the family understood in the patriarchal sense, the values of the prevailing religious cultures. In some countries, such as the Mediterranean and southern countries, family disputes were entrusted to religious courts, such as the Catholic ecclesiastical curia, Islamic Sharia courts, or the Jewish rabbinical courts. Divorce was not permitted in a large part of the territory, and in any case it was subject to important restrictions based on criteria of culpability. In the countries which recognized it in law, which were primarily the Protestant countries in the north. Family conflicts, and especially those related to the implication of family breakdown, the implication for the children, have become exclusive competence of the civil courts. The civil courts deal with all. Without the divorcist tradition that exists in other countries, in this transfer of powers from private courts, religious courts, to civil courts, it was chosen to assimilate the procedural management to traditional methods of prosecution. That is well known. They were designed and these courts were designed primarily originally for economic or property conflicts in the scope of civil law. And for the prosecution and punishment of offenders in the criminal system, in both cases the method is inappropriate. With children, with the father are broken or abandoned, there are no useful tools available to the jurisdiction. There are no effective measures related to the phenomenon of domestic violence, essentially against women, or the violence of teenage children against their parents. There is a lack of depth of analysis of the causes. So the causes are not well diagnosed in the social policies, are notoriously inadequate and unidirectional, with single direction. There is also the absence of a strict rigorous area of training of outreach of the proper legal culture which should come from universities. In general, the academic community does not meet its role to promote a system, but on the one hand has to be very specialized, and the other hand should reveal a strong multidisciplinary character. There is no extensive legal research. There's no postgraduate programs. Legal doctrine is very limited. There have not been any interdisciplinary partnerships or alliances that would help to address the lack of depth of this issue, nor the seriousness of the structural domestic violence, or the impact of the coexistence of different cultural models that immigration brings. In the law system of positive law, family procedure rules should provide legal practitioners with the specific, special, and adequate instruments so that effectively family judges working with specialized teams will be able to address these delicate conflicts that emerge after family breakdown in the relationships of fathers and mothers with children, with the guarantees that decisions will be adopted with the greatest efficiency. These rules should also have an impact on the form of lawyers, foreseeing a specialization in the area of family and children, in order to overcome the primitive style in which functions to engage their clients in litigation, which is very adversarial litigation at any cost. Now, we have the European Court of Human Rights, and the European Court of Human Rights has developed a certain jurisprudence in this area. Recently was activated the ECHR signatory member states of the Treaty of Rome. This legislation has had an impact on the issues related to the rights of minors to maintain the effective links with two bloodlines of their family, the maternal and the paternal bloodlines, with repeated sentences to member states when they do not affect these guarantees in family relationships, and so the relationship would not be broken down in either case. In fact, the court decisions that resolve disputes in this area should not mean the end point of the jurisdictional function, but that the judicial system should take measures to safeguard the interests of the children in order to provide the highest possible quality of the relations with the children with both parents and in their both dual family environment. Based on these postulates, it is now being imposed certain obligations to keep track of the court measures imposed and the resolution and the legal decisions concerning parental relationships, and especially if there's no specific unrest, it is required, they must adopt necessary ad hoc measures and take into consideration the concurrent circumstances, especially the disability of the minor, and the resources available to the court to enforce this. Intervention by lawyers in defense of their clients usually ends after final judgment, after the final judgment is issued. Although the family cases, the underlying conflicts, have not been solved. They are ongoing, and frequently regardless of whether judicial decision is rendered. Sometimes the opposite takes place, and the escalation of tension and conflict, feeling from the feeling of defeat by one, victory by the other, can lead to increased conflict. In these situations, the parents are upset with the children, and the children are forced to take sides with one of the parents, who are based on the judicial decision. This represents a serious risk that the relations break off even more after final judgment. Traditional statutory instruments are not sufficient. The protection under criminal law of the visitation rights should not just serve as a deterrent, since the children have their own system of values, and criminal prosecutions or the imposition of strict measures might cause alienation against one parent, which usually occurs. The meeting points, the psychosocial teams, trade over the children, they're useful terms, but they're not the only ones that the court may use for shared visitation. Some such have to establish alternative measures, monitoring therapeutic process. This is the case of analytical controls in cases of drug addiction, the family services with family members who have a sufficient authority to act as a bridge between two parents. These may be uncles or grandparents, or the intervention of teachers in education institutions. The appointment of a parental coordinator is sometimes necessary. The important thing is to ensure the stability and the interest of the minor. Although it is common that in some cases the children's attitude is reluctant to cooperate and they do not always understand, children must be respectful with the compliance of the rules as well, established by the court, that have already assessed what is in their best interest, even if the children are sometimes very reluctant. The deterioration of parental relationships, the most important risk indicators for consideration are the existence of violence or other types of abuse, addiction, drugs or alcohol, risk of child abduction, obsessive pathological attachments may also be a problem. Lengthy estrangement of one or the other parents. Transition between models of custody, individual custody to shared custody. The support of infrastructure available to the parents. Imputation of guilt to one and innocence to the other. absence of skills management or to manage the relationship post a breakup, problems arising from conflicts within the family home, increasing tranquility in family relationships. Auxiliary instruments that European courts are establishing for this case are varied. There are many different types. There's a follow-up by mediations, first of all, that work post-sentence. Social teams appointed by intervene as specialists in but their participation in the execution phase of the judgment. In many cases, technical specialists for judicial support are very aware of what's going on in the family realities, and they intervene to elaborate the first psychosocial opinion or legal expertise. They may be the appropriate technicians to make a timely follow-up, especially when the parents have made certain commitments towards the minor children, and they can help to maintain good relationships. And in every case, because in each case, they should discover what is most effective to ensure to reach the objectives in the shortest possible time. This specific intervention is intended to help healthful growth and development of the parties involved in the conflict, both parents and children, allowing them to deal with their anxieties, changes, with grieving, mourning, that the members of the family are undergoing. The specialized technicians in these psychosocial teams should play roles of containment, encouraging reflection on the part of the parties. Definitely giving direction and providing new meaning to the relationship should be their most important function. The second type of instrument, there's meeting points, intervention, family intervention, meeting points, quote unquote. Family meeting points are an accessory tool to the courts. The purpose of these family meeting points is to provide the court with a suitable means to facilitate delivery and transfer of children in case of serious couple conflict. As they should facilitate meetings with the parents, with the children, when there are problems in the problem solution in the conflict relations. Family meeting points offer a temporary shelter or a place of neutral and suitable meeting for visitation of the minor with the family, guaranteeing the right of the children to remain in contact with the other parent. Family meeting points are a social resource, or a specialized social resource for the intervention in conflict situations where the relationship of minors is at risk, or may even be interrupted or obstructed. Such intervention has the main purpose to normalize a conflict situation. Following any case, parental coordination, this is a tool has demonstrated to be very effective in comparative law, and it appears to be in comparative law, especially in the United States and Canada, for the normalization of the relations since its functions are diverse and relies on the management of multidisciplinary techniques. This figure is based on the consideration that in many families, the breakdown of the couple implies the need for new guidelines in terms of behaviors and habits, and implementation of this requires at a minimal level of cooperation, or goodwill, which sometimes exceeds their capacity because of the parents. Therefore, it is common, especially during the implementation phase, that there be an outbreak or an escalation of conflict which cannot be controlled with the resources available to adults and the children involved. At the end of the trial, the court trial, the procedure before the court is execution of judgment can often become very difficult. The situation sometimes and very, very difficult, because sometimes after the battle in court, we have to go into enforcement. In many cases, the citizens face a difficult situation. They have difficulty on the rules that have been imposed, especially the rules related to children, that must be executed even though conflict may be associated. That is something. The parental coordinator, in the form that is understood right now in Europe, is a cooperation, an expert recognized by the court, and often the lawyer will act on issues of shared parenthood in conflictive relationship. They must look to a new relationship based on respect, especially for the benefit of the children, which must be consolidated and strengthened towards in view of a better future. Let's talk about situations where there are other risks, especially risks of addiction or mental illness in one of the two parents. The laws enforcing certain conflictual relationships required at minimum are established with reference to the basic behavior of the parents. For example, the respect of the life and the physical integrity of the persons. The care required for children, basic maintenance for children. However, often in reality, in which the rules are presumed to be sound, but often the individuals involved do not have the ability to understand, or do not have the will to really understand the consequences of their own actions or behavior. What the legislator does in these cases is to consider the liability or the responsibility of persons whose behavior is conditioned by certain pathologies, psychic disorders, in punitive law, or when there's a violation of criminal offense. The law provides a whole system for mitigating any aggravating circumstances or even situations of non-imputability that determine the degrees of criminal responsibility to adjust the judicial response to the actions exhibited in persons who do not have sufficient capacity to make them responsible for their acts. The clinical pathologies have been diagnosed. They may be evident through external symptoms. They generate other problems. Since family groups have already been established, a special sphere of protection in social relationships in which the persons diagnosed are involved. However, there are other cases, if they are undiagnosed, that's where the difficulty arrives, which are patients, or many of those whose behavior exposes their children to risk situations due to addiction or drugs or alcohol, which is often hidden. The influence of a less involved mental illness, especially when the mental illness is not under control and when it's not necessary, to abandon the adversarial nature of legal proceedings. Since situations of tension and anxiety only will be exacerbated and may become a breeding ground and lead to ruthless clashes between members of the group. When these circumstances occur, it becomes necessary to set a conciliation phase, protected by confidentiality, in which can be undertaken a joint intervention of psychologists, psychiatrists, therapists, and social workers that perform their functions in coordination with a judge and giving a therapeutic sense to the work of the course. In Europe, the therapeutic jurisprudence movement is managing a project called Respect the Right of Your Children. It's a support program for many post-family crisis parenthood relationships, focusing on promoting the use of family mediation cases where the courts, at any stage of the prosecution, may detect the existence of minors that are at risk of losing the relationship with either of their parents due to the development of conflict during family proceedings. The objective of the protocol is to develop protocol for referral to family mediation in such cases once risk indicators have been identified without the need of causing a stay of procedures, but favoring the joint and coordinated action of the court with all professionals involved. And in conclusion, the last area, we'll talk about court intervention in cases of domestic or gender violence for prevention of risk to children. There are many cases in which the presence of elements of physical or psychological violence, serious behavioral disorders, should inform the action of judicial proceedings in coordination with the psychological or education, even in cases where a sentence of imprisonment for the perpetrator of violence is appropriate in accordance with legal rules. The activity should be aimed at the healing of the illness, addiction, or rehabilitation will be the best guarantee for the victim in various areas of social relationship. It is unquestionable the importance of providing protection for victims, as well as to guarantee that the victims be free from all risks involving rehabilitation, healing, or stabilization of the person who assaulted the victim. Such a requirement is more evident in family conflicts. It often occurred recently. In these cases, the litigation brought before the courts requires a new way of applying the principles of punitive justice, and it should be based on rehabilitative actions. Problem arising from the need for coexistence in a utopian society is to be addressed preventatively. The optimal is to carry out an early assessment that after the first symptoms will detect the existence of the seeds of future conflict. For this reason, it is desirable that the indicators be available to the school in medical interventions by injury, in consultations, couple therapy, or in any actions taken out by police services. But when the conflict manifests itself with violence and is at an advanced stage, criminal action will be required and criminal measures will be appropriate. But it is not enough to increase the catalog of criminal conduct or to aggravate the criminal penalty by giving, even those techniques are sometimes necessary. There must be something more effective, must be done to ensure the safety of the victim in the future. Certainly, there is the aggravation of sentences for certain types of criminal offenses in terms of the administration of justice, in particular in certain types of therapeutic conventions. But in the long run, many of the perpetrators of these crimes don't have the capacity of discernment that may lead to a change in their attitude, and it is only by fear of a more serious sentence. And emphasis that is the gender-based violence area. There are many offenders that don't care about ending their lives or ending up in prison. They are recidivists in certain cases, and appropriate therapeutic treatment at an earlier stage might have avoided fatal outcomes. In forensic jurisprudence, there is the occurring reiteration of cases that are symptomatic of what I'm talking about, and which merit objective consideration. I'm referring to the incomprehensible phenomenon of the disaffection of the children towards victims and its link with the abuser. Because sometimes the sentence, which is excessive, will engender in the children a feeling of closeness and support to whom they consider to have been treated unfairly or have been excessively punished and ultimately helpless. In this way, they end up accusing the mother of being guilty of the punishment inflicted on the other parent, which was undeserved, and which is normally the father. Unfortunately, this type of cases occurs with a certain frequency And they highlight that the legal system did not offer to the woman the attention she needed, that is, to provide psychological support to the children. It should be emphasized that the imposition of severe criminal sentences is not incompatible with some psychotherapeutic interventions for all members of the family, because the goal is to safeguard not only the integrity of the victims, but also the rehabilitation of the aggressors, thus avoiding the children become the final, indirect victims of a system that has not taken the proper care of the children's interests by providing them with adequate psychological assistance to know how to discern the causes of the problem and the need of the justice to act with rigor while respecting the civil rights of all persons. In conclusion, the family justice should not be limited to technical and strict enforcement of the law. The interests at stake are those of vulnerable persons, minors, victims of violence, the mentally ill suffering from certain symptomologies that affect their behavior or drug addiction. These require action of multidisciplinary teams. The implementation of joint intervention protocols in many of these cases might lead to a reduction in the area of litigation that consumes so much personal and material resources. This is the right way in cases of physical or mental violence, unlawful transfers of children, or abduction, in cases of conflictive breakdown, or in conflicts arising from the various ideological perspectives present in a multicultural society. But above all, coordinated action based on the principles of therapeutic jurisprudence would be appropriate to provide children, youth, and adolescents with experience, particularly that experience situations of great conflict and difficulties in their lives. It would be an important stepping stone towards the restorative family justice in which the victims, whether direct or indirect, would be protected in a comprehensive manner. Thank you very much.